All right, thanks for staying with us. Let's stay now with the developments at the Electoral Court and speak to Tselane from the Institute of Election Management Services in Africa. He's the executive chairperson there, as well as Wits School of Governance political analyst, Professor Susan Boyce. And let me thank you both for your time. I'll ask you the same question as we kick off this discussion. I'll start with you, Mr. Tselane, your reaction to the ruling.
I would have been surprised if the Electoral Court had come to a different conclusion, largely because the issues that were raised, I think they were valid enough, particularly in terms of the power of the Electoral Commission to administer Section 47, as well as the other issues that were raised by the Council for MK Party. And
for you, Professor Susan?
Well, I think this harbors a great day, a very important day, I should say, in South African politics. I think it will go down in history roughly similar to dates like 14 February 2018, when former President Zuma was ousted. It is a very significant day, and it is very important direction that the Electoral Court gives with regard to inclusiveness of politics and granting the right of participation to possible parties against whom there might have been questions, on which fronts there were some very important technical arguments, which I really look forward to see the full judgment in due course to help us understand these issues. There were so many other points raised at IEC and their council yesterday did seem to be entirely rational. But this is a very important new interpretation that comes from the Electoral Court. And through that, it probably postpones or diffuses, hopefully, all possible insurrectionist motivations and mobilization against electoral processes. I think the day is particularly important in terms of channeling participatory energy in South Africa into the elections process. And so that was very significant in that way.
And I want us to get into, in just a moment, what this means then for former President Jacob Zuma politically, Professor Boyson. But let me stay with what you said, Mr. Tselane, because the powers of the IEC came into sharp focus yesterday. You've touched on it a little bit. I mean, the lawyers for the former president saying that their powers are limited as far as managing, managing the elections, and also emphasizing for them what they call the importance of separation of powers, and saying that it is the National Assembly that holds the prerogative to determine the membership eligibility. So listening to what you're saying, then you're saying that this was also tested, especially when we look at what was argued in court.
Absolutely. I mean, if you look at Section 47, Section 47 refers to candidates for the assembly. Candidates for the assembly are the 400 members who become candidates until such time that they are sworn in into parliament as members. So they are not members until they're swearing in. And the candidates that the Electoral Commission is responsible for are not in Section 47. It is the 15,000 candidates that contested the elections. And when you look at Section 47, there are many exclusions. It is not only the issue of criminal record. It is the issue pertaining to whether a person is in the employ of the state, whether a person is a member of the municipal council or provincial council. And therefore, it could have not meant that the Electoral Commission has got to exclude all those people on the basis that they are candidates and then they are serving in different portfolios. The reason why this aspect is actually put under the National Assembly in the Constitution, it is in order to make sure that those who are excluded should not actually be members of the National Assembly. In other words, there's got to be a mechanism that the National Assembly introduces in order to be able to check the eligibility of all those people before they are sworn in. And they would be able then to remove those who are not supposed to be there. If, for instance, you are a member of the provincial legislature or municipal council, you can't hold two positions. You can't be in the municipal council and at the same time be a member of parliament. And that's why you've got to either resign your position and not become a member of two structures. So Section 47 was never really meant for the Electoral Commission, but it was always meant for entry into the National Assembly. And it regulates only 400 members who then get elected into the National Assembly, and not the 15,000 who become candidates.
So I want to stay with what you're saying then. What does it mean in the practical sense? For example, post the elections, that, someone then comes and they did, become successful, maybe from their political party, and then they are able to then get into parliament. Does it mean there's another hurdle that they need to jump over here?
Yeah, absolutely. It means they've got to be checked against the criteria that is there within Section 47. Let's assume for a moment that the Electoral Commission was laboring under a misapprehension that they are responsible for the administration of Section 47. If they were going to have to do due diligence on all the 15,000 people against the criteria that is there in Section 47, in order to be able to establish as to whether those people, for instance, you don't have a person who's been regarded as insolvent by the court of law, has not been regarded of unsound mind. We can't just focus on one aspect, which is that of the criminal record, as though it is superior to any other provision that is there within Section 47. They would have to have that and check that against every person who is actually elected. And they would have to look at the 15,000 odd people who become candidates. So the intention was never really for the Commission to administer it. And the Commission also understands that it is not their responsibility, because if it was their responsibility and they have not done the due diligence in all 15,000 people, it would have meant that they have actually failed in their constitutional duty. Yeah. And then, and then that would be even a much more serious breach.
Professor Susan, you say that this is quite significant as far as the right of participation, the inclusivity aspect of it, especially when it comes to this particular ruling. But others are then saying, the MK party's big draw card was the former president. And I wonder how much of a boost then is this for the party, and what does it mean politically for the former president?
Yeah, I definitely think it was a big boost, not just for the party, but for President Zuma, former President Zuma himself, because the party and the person really go hand in hand. Without him there, the party would have taken a big knock, but knowing the party and the people and the kind of constituency that it represents, that it draws in, there would probably have been a lot of agitation, a lot of mobilization, and possibly a lot of destabilization in the 2 months ahead, running up to the elections, had this not been the case. So this is a stabilizing effect, even if it's not universally politically popular.
And
it definitely will. It will definitely boost the chances further. We've already seen in public opinion polls of recent months, ones that work with good samples, that the party has got substantial support in KwaZulu-Natal. And one doesn't want to think that this would have been a type of blackmailing into getting into the election instead of pursuing threats to destabilize, but it will de facto have that effect in stabilizing the province and making it the party a legitimate vehicle to support.
And Mr. Tselane, how much then of a challenge does this also pose for the IEC? If they do choose to appeal this particular decision, for example, to a higher court, looking at the timetable that also needs to be published as well, how much of a corner does this put them?
Well, the IEC would be ill-advised to take this matter to the Electoral Court, to the Constitutional Court, for many reasons. Firstly, it is not their issue. They are not the ones who are objecting. They were upholding an objection by someone else. And therefore, for them, the issue ends here. And I remember that there was an issue similar to this previously in 2009, relating to Miss Winnie Mandela. And immediately when the commission when the decision was taken to allow Miss Mandela to become a member of parliament, the Electoral Commission did not actually appeal to the Constitutional Court that decision and just accepted it. So apart from the fact that they are tied timeframes. This is not a matter of the IEC, and it would be really ill-advised to even begin to consider taking it to the Constitutional Court. And I doubt it that the Commission will actually want to be seen to be fighting tooth and nail on an issue where they're not an interested party.
You agree, Prof?
Yes, I agree. They were really acting on behalf of complainants, not they themselves. And I think the IEC is very keen to accept the guidance, to accept the type of direction that the Electoral Court gives in this regard. The Electoral Court, of course, has got a high standing at the same level as the High Courts of South Africa, different divisions of the High Courts. So it is a senior court that is pronouncing there. And I'm pretty sure that the IEC sees themselves as the administrators of the law and to the best of their ability and taking the guidance that is provided by the Electoral Court. I would be surprised if they take it further.
And Prof, how much would you say, I mean, looking at the journey that South Africa has travelled 30 years on and looking at this highly contested election that we're going to on May 29th, how much of a test would you say this was for, the country's democracy?
I think it's a huge test for democracy because there are so many different layers of contest in South Africa, not just the direct level of electoral contest, but also a party like the MK party of a particular type coming in and claiming to be actually a better version of the ANC. And this is a particular kind of challenge which is now being put on one dimension with other political parties in the electoral contest. So I think that was a good step forward, a step from which democracy 30 years on and after several all of them very successful elections, a highly contested one, helping to even out the terrain, smooth the terrain in the run-up to this election.
And a mammoth task lies ahead for the Electoral Commission, as we wrap up, because when you think about how everyone is looking at this particular election, how highly contested it is, this is but one of the many issues that the IEC needs to overcome now, and it will be important for them to be seen to be above scrutiny, especially when you think about this highly contested election.
Absolutely. I think the Electoral Commission must appreciate the significance of this moment and make sure that going forward there is nothing wrong that is going to appear in terms of the way they manage the electoral processes. They've got to understand that there is a lot of scrutiny in how the elections are managed, particularly because these elections are going to be highly contested. So they cannot afford to be complacent in terms of how they are going to be managing this process. And I think it's important for them to really work much harder than they've been working in order to make sure that they are able to run a smooth operation.
All right, let me thank you both for your time. Long nights ahead as we look to May the 29th. It's going to be a lot of work, but let me thank you both for helping us even understand this significant moment in our democracy. That was the Institute of Election Management Services in Africa Executive Chairperson Terry Tselane, Invest School of Governance Political Analyst Professor Susan Boysen.